And let's continue. Again, I am in Article 9, Probationary Period. Paragraph 3. If the worker wishes to move during the probationary period to work for another employer in the state, he shall notify the original employer of the same in writing within not less than 1 month from the date of his wish to terminate the contract. Then the new employer shall compensate the original employer for the cost of recruitment or contracting with the worker unless otherwise agreed upon. This is an interesting paragraph. You see, if a worker wishes to terminate a particular contract with a particular employer in order for him or her to sign an employment contract with another employer, that means the particular worker should notify the existing worker 1 month in advance for his decision. That means to terminate the contract. And also, in addition, the interesting part of paragraph 3 is that the new employer of the particular worker shall compensate the original employer for the cost of recruitment or contracting with the particular worker unless otherwise agreed up. It's like you say, it's like the particular, let me tell it again, in a low speed, let's say. It's like the particular paragraph is saying to the reader that in such occasions either the new employer of the particular worker will compensate in some way the original employer, or the original employer have the right to sue the new employer. That means to bring the new employer in front of law, in front of a court. Let's move. Paragraph 4. If the foreign worker wishes to terminate the employee, if the foreign worker wishes to terminate the employment contract during the probationary period to leave the state, he shall notify the employer of the same in writing not less than 14 days from the date specified for the termination of the contract. If he wishes to return to the state and obtain a new work permit within 3 months from the date of departure, the new employer shall pay the compensation stipulated in clause 3 of this article, unless in case of an agreement between the worker and the original employer to the contrary. So as I understood, each article have clauses, not paragraphs. So for example, Article 9 probationary period have 7 clauses. And each clause provides let's say each clause provides a context, a particular context for the probationary period of the employment agreements in the United Arab Emirates. And okay, the clause 4 is very interesting because somehow I'm not able to speak as I would like to speak. I don't know why. Maybe it's because it's winter or because it's Christmas time. I don't know. Maybe. In a sense, I'm not a person that speaks a lot, and that's why I'm wondering why I'm not able to speak clearly. If the foreign worker wishes to terminate the employment contract during the probationary period, to leave the state, in order to depart from the United Arab Emirates to go to another country, let's say, the worker should notify the employer of the same in writing to not less than 14 days. For example, if I wish to terminate my contract with Emirates Aviation Group, then I need to notify Emirates 14 days in prior. And this is if I want to terminate the contract and permanently leave the country. And if I want to terminate the contract and immediately after the termination of the contract, I will leave the country. I will not stay in the United Arab Emirates. Then I may do so in 14 days. Let's say if I am in the early stages of my contract with Emirates, if I attend the aviation college and I would like to resign, I would like to terminate the employment and in addition completely move out of the United Arab Emirates and come to Cyprus, let's say, then I may do so by providing a 14 days notice for the termination of the contract. And if I wish to return to the United Arab Emirates and work for a new employer in a time span of 3 months of my initial resignation and depart from the United Arab Emirates, then I may do so. But of course, the new employer have to make the necessary arrangements for the new work permit, and also the new employer should, as indicated in clause 3, shall compensate the original employer for the cost of recruitment or contracting with the worker, unless otherwise agreed upon. Unless in case of an agreement between the worker and the original employer to the contrary. So that means in the case that an example again, and let me give an example. Let's say that I was able to join Emirates in the role of cabin crew. If I would like to terminate my contract and leave the United Arab Emirates in the same time, then I will file, let's say, a 14 days notice. After this, if I was able to land a contract with another employer of the United Arab Emirates, then I am more than able to, let's say, as I understand, I am more than welcome to return to the United Arab Emirates under my new employer contract. But if this takes place in a time frame of 3 months, months of my initial resignation with Emirates, let's say, then the new employer have to compensate to Emirates the cost of recruitment or contracting with me, unless if otherwise agreed upon, unless if there is another agreement in place. Else, if I do not want my new employer to in any way compensate Emirates for the recruitment process, and let's say the training process in the Emirates Aviation College, then I may come in an agreement with Emirates. And let's say, I may say, it's the Emirates may, according to law, may identify that the total cost of recruitment and the total cost of training is so much dirham. So please how to say in English? Please compensate. So if I compensate that, if the worker comes in an agreement with the original employer and compensate the necessary recruitment cost, then the new employer have not to do so. This is what the paragraph, the clause 4, identifies. And here's conclude the second video for the Article 9, probationary period of the labor law of the United Arab Emirates. And I will see you on the next video that I'm going to discuss Clause 5, Clause 6, Clause 7 of the Article 9.